Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. My name is Arianna Gonzalez, and I'm the Client Services Manager here at Chug Attorneys and CPAs. Please join me in welcoming Attorney Esther from our Herndon, Virginia office. Hi there, Esther, and welcome.
Hi, Arianna. How are you?
Doing well. Thank you so much for being here with us, Esther. So for today's topic, we're going to be talking all about NDAs and DBAs. So before we begin, I'd like to remind you all that we are live on YouTube, LinkedIn, and Facebook. This conversation is for informational purposes only and does not create an attorney-client relationship. Make sure you email any questions you have to us at info@chug.com and we'll be happy to help you out. So let's get right into it, Esther. Let's start with NDAs, non-disclosure agreements. What is the primary purpose of NDAs in business transactions?
Sure. Thank you, Ariana. This is a very good question because when the clients coming to me, they have fantastic ideas, specifically for the people who want to put their ideas into the business. They want to find partners or prospective clients or prospective partners to discuss how fantastic idea is and what the steps to put their idea into the business. That's the reason why we need an NDA, which is non-disclosure agreement. It is agreement protecting sensitive information between the parties who signed this agreement. So basically, if you have fantastic idea and you don't want people from stealing it, so that is a good opportunity to have one. So when you sign an agreement with the parties and then they're not able to disclose the information like sensitive information or confidential information when you try to exchange the idea between parties.
So NDAs clearly have a vital role in protecting our business ideas. So let's get a little more specific on the how. How can NDAs protect our proprietary information from misuse or theft?
Sure. So as I said, NDA is agreement, right? It is a binding agreement as long as it's properly drafted. So which means that when people draft an agreement, they agree that they have the obligation to keep the confidential information only within the scope of service or scope of work. So in that case, in this agreement, there will be a lot of key clauses to deter people from disclosing it. So for example, you will need to define what confidential information is and how long you need to keep it, even after the termination of contract. And of course, what happened if someone breached the contract and what is the damage the victim party can ask for. So this is all the information contained in the NDA, which will help people from keeping their sensitive information.
Great. So an NDA is kind of like a vault for our business secrets. So what are some key elements or clauses that should be included in every NDA?
Of course. So as we probably know, the NDA is a very comprehensive document, but the most important part, of course, make it clear and not ambiguous. So you will need to have a very clear definition of confidential information. So you will need to define what you consider as confidential information. For example, when the people exchange the information, they probably can, put confidential word on the cover page, make it a confidential information. Of course, another term which is going to be the term of confidential agreement. So which means that, how long the people has to keep that as the secret and confidential and it shall not disclose to the third party. And of course, the breach of the contract and the damage, as I mentioned. So these are all very important clauses. And of course, there are miscellaneous clauses such as governing law, which, if there's a litigation, where it should be brought up. So these are all miscellaneous clauses are also very important. But as I mentioned, the definition, of course, is on the priority.
Thank you for sharing that information. So basically every clause plays a crucial role in the NDA. So let's get into the lifespan of these NDAs. How long does a typical NDA last and how is the time period determined?
Yeah, it is really a good question. So what happened is when you have NDA, it of course need to be reasonable, and it always based on the negotiation between the parties. What I would say is common case, there will be 1 to 3 years even after the termination. But if it's a very sensitive scenario, the people are free to extend the term. So which means it can be longer.
So it's not a one size fits all approach for NDAs, basically. So let's talk about what happens if someone potentially tries to breach the NDA. What are the potential legal consequences if an NDA is breached?
Of course, I think that's a really, wonderful question. And people try to approach attorney and to see whether there is a serious consequence behind it. Of course, if the NDA is properly drafted and not vague and clear, so of course in that case that the breaching contract is definitely not a good thing to do, because the unbreaching party can claim for the monetary damage, consequential damage, and of course injunctive relief, which means ask the breaching party from not to do so. So these are all the damage and the remedies that the victim party can asking for. It is a very important clause that's in the NDA, and of course it depends on case by case.
So it sounds like there would be severe consequences for anybody who does breach an NDA. Are there instances when NDAs might not be legally enforceable? Can you talk about that a little bit?
Sure. I think what happened is there are very important key clauses in the NDA to make it valid and enforceable. But however, sometimes the people try to include everything as a confidential information, which will make it vague and unclear. In that case, there will be a very valid defense for a breaching party because they can argue that the contract is not enforceable and not valid because the clauses are not clear, and it's ambiguous. So take confidential information as an example. The definition of confidential information must be very clear and precise, and you'd better to describe it a way that the both party can understand. And of course, if you fail to do so, for example, if you just try to include everything as confidential information, it is impossible to practice, which will make this agreement unenforceable. For example, if there is no exclusion clause, for example, the information they have already known to the public shouldn't be considered as confidential information. So if you have such exclusion clause on the agreement, it will be very helpful.
So precision seems paramount in drafting these NDAs. So let's talk about common pitfalls to avoid when crafting these protective agreements. So can you share some examples of common mistakes that most people make when they're drafting NDAs?
Sure. So as I said, the first one, the people really don't that care but when attorney come in, they will to check what the jurisdiction is of the agreement, because when the jurisdiction will decide where the dispute should be solved, in which state. So in that case, people need to be taken care of when they really considered these issues, because sometimes it's in the miscellaneous clauses and it's not that important to them. So and also it happens in the future. So if that's the case, the people probably will not take it seriously. So this is one common mistake people probably gonna miss. Another one is that, as I said, the definition. So for example, the information have already been acquired by the receiving party should not be included in the confidential information. So if you make it too broad, of course, it is hard to practice and the agreement can be not enforceable at that time. So this is the common mistake that the people probably don't want to make. So just keep in mind.
Those are great tips to keep in mind. So now, are all NDAs created equal, or do we have different types, like one-way NDAs and mutual NDAs? Can you talk a little bit about that, and when might each one be used?
Sure, there are different types of NDA, so it always should be case by case. Let's take an example. If it's one-way NDA, so which means that only the party received the information will have the obligation to keep the confidential information, and it's one way. So for example, if I have a company and I do want to, develop my ideas, so I do have my data and I want to create something new, but I need to hire, the service company to help me develop software. But during that procedure, I need to share my very sensitive data, including my client marketing, material, to put it in my software. So in that case, the service provider is only the party receiving such confidential information. So in that case, that it can be a one-way NDA because I'm only the party who's sending such confidential information. But however, for example, if I want to find a partner and we're going to work together and I'm going to be responsible for the marketing and they're going to be responsible for the technique sharing or development. So we kind of working together. Both sides have very sensitive information, including client list, including the marketing strategy, or of course the data commingle together. So if that's the case, of course, you will need to have a two-way NDA to protect the both parties and to make sure that none of them can be breached.
I appreciate you clarifying the difference between one-way and mutual NDAs. So now let's shift gears to DBAs, doing business as. Can you explain what a DBA is and why a business might use one?
Sure. So DBA is very different, but it's also very helpful, specifically when the company want to have their brand out in the market. So the DBA is a legal term referred to fictitious name, assumed name, any name for the branding purpose other than the legal name. So for example, you can think of I think probably you will know the corporation will say ABC Corp, right, or ABC LLC. So, but however, when it comes to the fictitious name or what we said DBA, you can have a more attractive name or a dramatic name to make it very attractive to the client and customer. So therefore, it is a name under your real legal name, but it's attached to the legal name.
So it's basically like a business pseudonym. So let's talk about the steps to filing a DBA and how long does this typically take?
Sure. First, the DBA it depends on the state from state to state, and it can be very different based on the case. So, for example, in Delaware, there will be a form that you need to fill out, and there are like 3 counties that you can choose where you want to use your DBA, and it's gonna be protected within that area. But however, in other states, let's take Virginia example. Virginia, you only need to file it electronically, and there is no, counties that you need to choose. So it is a one file electronically. So it's gonna be easier and straightforward. So it really depends on the procedure and the policy of the different counties or states.
It's pretty fascinating how much the filing process can differ from one place to another. So let's get into legal and financial liability. How does operating under a DBA impact legal and financial liabilities?
Sure. So the DBA, as I said, it's just a fictitious name. So what you're trying to do is you try to brand it. You're trying to use the name under your real legal entity to do the marketing. So actually, it's not gonna have any liability impact. So what I'm trying to say is that even you have a DBA will not prevent you from any liability. Everything will be the same. Exactly as you don't have it. So basically there will be no difference. But however, when you have DBA, it is always advised that you to disclose your DBA with your LLC or corporation to make sure it is precise and there's no miscommunication between the parties.
That's good to know. So it's more of a nameplate and it doesn't really alter the liability. So let's get into the legal obligations. What are the legal obligations that come with operating under a DBA?
Sure. So when I said DBA, of course, the people want to use this name to attract the people. They want the people recognize this name, at the first sight. So that's the reason, the DBA comes into the picture. So when you sign an agreement, as I said, you have to put both the legal name and the DBA on agreement. That will be very helpful to clarify any, miscommunications. This is the first thing. And the second thing is that you will need to make sure that it is very clear that there's no such fishy thing or phishing ads there which confuse people or business partners. So as long as you are clear about these 2 points, you are good to go.
That's good to know. That's really helpful information. So for anybody that's just tuning in, we're talking about NDAs and DBAs. This conversation is for informational purposes only. It does not create an attorney-client relationship. So please email us your questions at info@chug.com and we'll be happy to help you out. Let's get back to the conversation, Esther. So can a single company operate under multiple DBAs? And if so, what are the implications of doing this?
Sure. So it is a fantastic question because if you only have a very small company and you only have like one kind of service, you don't need multiple DBAs because there's no difference for your company. So it really based on the needs of the scenario and the actual needs of your company. So for example, if one company has different types of products and they try to differentiate from each other. Take, for example, if I have a company and I do have multiple products, different products, I have clothing, I have baby product. So if I want to, differentiate them, so it is smart for me to have different DBA. In that case, although I only have one legal entity, but since when I do the marketing, the different customer can recognize me immediately from my DBA. So that's the reason why people want to have multiple DBA, under one entity. But however, it is of course, a concern, or you need to take extra precautions because you have multiple DBA. So you will need to make sure that doing different business activities will not impact each other when you have multiple DBAs.
So basically having multiple DBAs can be a strategy for market segmentation, but also might carry some risks.
Right.
That's good to know. So does a DBA protect a business name from being used by others? Can you talk about that a little bit?
Sure, because actually it's a really good question. A lot of clients coming to me say, "Hey, Esther, I'm not sure whether I want a DBA or trademark. Can you give me some advice? Does that mean that if I have a DBA, nobody can use exactly same DBA, or I can exclude people from the market by using a similar name or exactly same name?" But unfortunately, actually, it is not how it works because for DBA, you can consider it as more as a right to use a different name under the entity for branding purpose. So, for example, I have my Esther LLC. Just take an example, and then I have multiple products. I can call my products Esther 1, Esther 2, Esther 3 as different DBA, but that doesn't mean that I can exclude people from using exactly the same name in the area. So it is more like a right that I can use my DBA as a branding name, but it's not a right for you to defend from your competitor or competition. So that's the reason why trademark kick in, because for the DBA it's gonna be enforceable and valid within the specific area or state where you applied for, but for the trademark it is valid across the country. So basically, which means that it's gonna have a higher protection there.
So a DBA is more of a local identity and doesn't necessarily provide a nationwide shield against others using the same name. So can you expand on this a little more? Can I have both a DBA and a trademark?
Yeah, it's a very smart actual solution. The reason is because for DBA, when you applied DBA and you're using it when you're doing the marketing, so which means you're actually use such name in the market, right, in commercial use. So that is a strong evidence for you when you want to apply the trademark. So because in the trademark application, you will need to certify. There are, of course, the different classes, but I'm trying to say if you're trying to prove that you have already been used the logo or the name that you want to trademark, so you will need to submit the evidence. So the DBA that you once applied can be a very strong evidence to prove that you've already put it in commercial use as an evidence. So of course you can have both DBA and trademark, and it is definitely a good strategy there.
Thank you so much for sharing that with us, Esther. That's great information and so helpful to know that it is a great strategy to have both a DBA and a trademark. Once again, I really appreciate you taking the time to answer these questions and share your insights with us. That is all the time we have today. So this does bring us to the end of our conversation. Thank you so much for joining us today. And to stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. And if you found this video helpful, please give it a thumbs up and a like. And please follow us on our platforms. Stay up to date. If you have any questions or suggestions, please feel free to send us an email at info@chug.com. And join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care.